Part 6 of Federalist 81 on your screen. As I've told you before, this is OU's Institute for the American Constitutional Heritage. It's a wonderful website. Tons of videos that are educational, that will help you understand the American Constitution better. It's a wonderful program at OU if one day you decide to study law or American Constitution or history, political science. It's a great program. Just go to the website and take advantage of all those lectures. It will help you understand the founding of the United States, the American Constitution, and of course the Federalist Papers that we are reading right now. All right, I am going to go to paragraph 20 and start reading there. But it does not follow that the re-examination of a fact once ascertained by jury will be permitted in the Supreme Court. Why may not it be said with the strictest propriety when a writ of error is brought from an inferior to a superior court of law in this state, that the latter has jurisdiction of the fact as well as the law? This writ of error was issued by a higher court to a lower court to find out details about the court, to see if there was an error, if they could find an error with the inferior court's judgment. It is true it cannot institute a new inquiry concerning the fact, but it takes cognizance of it as it appears upon the record and pronounces the law arising upon it. This is jurisdiction of both fact and law. And then Hamilton himself gives a footnote and says, this word is composed of jus and dictio, juris dictio, or a speaking and pronunciation of the law. Nor is it even possible to separate them. Though the common law courts of this state ascertain disputed facts by jury, yet they unquestionably have jurisdiction of both fact and law. And accordingly, when the former is agreed in the pleadings, they have no recourse to a jury, but proceed at once to judgment. I contend, therefore, on this ground, that the expressions appellate jurisdiction, both as to law and fact, do not necessarily imply a re-examination in the Supreme Court of facts decided by juries in the inferior courts. Again, remember, I mentioned this in the last part. Jury trials were very important to Americans back then, because they knew that if you don't have a jury, you put too much power in the hands of judges, and that might not be a good thing. So unfortunately right now, this is an unfortunate thing in the United States because of lack of civic education. People don't want to participate in jury duties, and they don't realize how damaging that is. And it's one of the most important rights and privileges they have. And they're just unfortunately not appreciating it. Then the next paragraph is, the following train of ideas may well be imagined to have influenced the convention in relation to this particular provision. The appellate jurisdiction of the Supreme Court, it may have been argued, will extend to causes determinable in different modes, some in the course of the common law, others in the course of the civil law. In the former, the revision of law only will be, generally speaking, the proper province of the Supreme Court. In the latter, meaning the civil law, the re-examination of the facts is agreeable to usage, and in some cases, of which prize causes are an example, might be essential to the preservation of the public peace. It is therefore necessary that the appellate jurisdiction should, in certain cases extend into the broadest sense to matters of fact. It will not answer to make an express exception of cases which shall have been originally tried by jury, because in the courts of some of the states all causes are tried in this mode. And then Hamilton gives another footnote which says, I hold that the states will have concurrent jurisdiction with the subordinate federal judicatories in many cases of federal cognizance, as will be explained in my next paper. And in such an exception would preclude the revision of matters of fact, as well where it might be proper as where it might be improper. To avoid all inconveniences, it will be safest to declare generally that the Supreme Court shall possess appellate jurisdiction both as to law and fact, and that this jurisdiction shall be subject to such exceptions and regulations as the national legislature may prescribe. So every time it brings up the word fact, just think of juries. Think of juries, because that's what juries would sit in a court. They would try to find what the facts are. Okay, so it says that's why they were forced to write the Bill of Rights in the first Congress, because a lot of people were really, really distrustful of powerful government, centralized government. So, and in this Constitution, when it came out of the Philadelphia Convention, they said, you've not provided for some jury trial in some cases, and the only way we're going to ratify this Constitution is if you promise that you will include it in amendments immediately in the first Congress. Okay, the last two paragraphs. This view of the matter, at any rate, puts it out of all doubt that the supposed abolition of the trial by jury by the operation of this provision is fallacious and untrue. The legislature of the United States would certainly have full power to provide that in appeals to the Supreme Court there should be no re-examination of facts where they had been tried in the original causes by juries. This would certainly be an authorized exception, but if, for the reason already intimated, it should be thought too extensive, it might be qualified with a limitation to such causes only as are determinable at common law in that mode of trial. The amount of the observations hitherto made on the authority of the judicial department is this, that it has been carefully restricted to those causes which are manifestly proper for the cognizance of the national judicature, that in the partition of this authority a very small portion of original jurisdiction has been reserved to the Supreme Court, and the rest consigned to the subordinate tribunals, that the Supreme Court will possess an appellate jurisdiction both as to law and fact in all cases referred to them, both subject to any exceptions and regulations which may be thought advisable. That this appellate jurisdiction does in no case abolish the trial by jury, and that an ordinary degree of prudence and integrity in the national councils will ensure us solid advantages from the establishment of the proposed judiciary without exposing us to any of the inconveniences which have been predicted from that source. Notice how he keeps on saying we are not going to lose jury trial, this and that. It's because anti-federalists were really, really upset about this fact. They thought you can't do away with juries, you can't get rid of juries. We have to have them in our trial system, and we need amendments added to the Constitution that will guarantee that. Otherwise, we will not ratify this Constitution, because jury trials are symbolic of a free government, of justice. So anyways, I hope you visit this website as well as other websites I've mentioned, and build your knowledge of the founding era, the history of the founding era, and these Federalist Papers will gradually make more sense as you go along. So see you when we start on the Federalist 82.